When cops ask to search you for weed, every word and action matters. One wrong move can turn a simple encounter into a serious legal issue. In this video, I'll explain your rights, what officers can and cannot do, and the smart steps to protect yourself during any weed-related search. What to do when cops want to search you for weed consumption. You're driving home late at night, windows cracked, the faintest trace of burnt cannabis in the air, blue lights flare in your rearview mirror. You pull over, the officer leans in and says the words that make most people freeze. "I smell weed." That one sentence changes everything, because if you don't understand what it means, biologically, legally, and strategically, you've already surrendered control. I've represented hundreds of people who thought that moment was harmless. They figured, "I've got nothing to hide," or "I only took a few puffs earlier." But here's the truth. Once an officer claims to smell marijuana, your body becomes evidence. Your breath, your eyes, your pulse, even your posture. And unless you know exactly what to say and what not to say, that simple statement can justify a full vehicle search, handcuffs, and a record that follows you for life. So I'm going to give you the exact insider knowledge lawyers use to dismantle these encounters before they spiral. This isn't a theory. This is how the system works. From the smell receptors in your nose to the search clauses in the Constitution. Let's begin with the foundation. How police use biology and perception as legal tools. When an officer says they smell marijuana, it's not about your biology, it's about theirs. The human olfactory system contains around 400 different scent receptor types, each linked to a unique family of volatile molecules. Cannabis emits more than 200 distinct terpenes, such as myrcene, limonene, and beta-caryophyllene. These create the plant's characteristic odor, but they also appear in hemp, and even everyday products like cleaning agents and cologne. That overlap is important because under US law, especially since hemp became federally legal in 2018. Odor alone no longer reliably distinguishes illegal marijuana from legal substances, yet officers are trained to interpret that smell as probable cause. The legal system allows that claim to unlock your privacy unless your state's courts have restricted it. Problem: the officer claims to smell weed, creating probable cause to search. Solution: calmly assert that you do not consent to any searches and that you choose to remain silent. Do not argue about smell or science on the roadside. Why it works. Consent is voluntary. Once you refuse clearly and respectfully, "Officer, I do not consent to any searches," you've preserved your Fourth Amendment protection. If they search anyway, your attorney can challenge it later. If you argue or volunteer information like, "I smoked earlier but not now," you strengthen their justification instead of weakening it. Now let's unpack the first legal principle every citizen must master: the difference between reasonable suspicion and probable cause. Reasonable suspicion allows an officer to stop you briefly to confirm or dispel a suspicion. Probable cause allows them to search or arrest. These are not interchangeable. The problem is officers often blur the two. Nervous movement, red eyes, or odor might be cited as indicators of recent consumption, but none of these confirm impairment. THC, the active psychoactive compound in cannabis, binds to fat cells and lingers in the bloodstream for days. Unlike alcohol, your THC level doesn't correlate linearly with impairment. You could test positive long after the effects fade. Police know this, but they also know the average person doesn't. Here's where your composure matters. Your body tells its own story during an encounter. Breathing rate, eye dilation, muscle tension. Officers are trained to interpret stress as guilt. That's why staying calm is strategic, not emotional. Problem: you appear anxious, and the officer interprets it as guilt. Solution: slow your breathing. Keep your hands visible on the steering wheel or by your sides. Speak slowly and deliberately. Why it works: you control the narrative. Calm, clear behavior undercuts claims of nervous demeanor, which officers often cite in reports to justify extended stops. Now let's step back from physiology to law. The Fourth Amendment of the US Constitution protects you from unreasonable searches and seizures. That phrase, unreasonable, is the fulcrum of nearly every weed-related case. Because the amendment doesn't forbid all searches, it forbids those lacking justification. The Supreme Court has carved exceptions: consent, plain view, exigent circumstances, and the automobile exception. For weed, police rely mostly on the last two. The automobile exception says that if an officer has probable cause to believe evidence of a crime is inside a vehicle, they can search without a warrant. Originally, this existed because cars are mobile and evidence could disappear, but today, that exception is the gateway for most roadside searches. Here's the catch. In states that legalized recreational or medical cannabis, courts are redefining what probable cause means. For instance, in Arizona and Illinois, the odor of cannabis alone is no longer enough. Officers now need corroborating factors: visible weed, impaired driving, or confessions. But in states like Idaho, Kansas, or South Carolina, smell remains sufficient. So if you cross state lines with weed in your car, your rights change instantly. That's why you must always know where you are. Federal law still classifies marijuana as Schedule Y, meaning it's considered as serious as heroin under the Controlled Substances Act. Even if your state allows use, federal highways and national parks don't. One mistake, like carrying edibles across a border, can trigger federal jurisdiction. Problem: you're pulled over in a state where marijuana is illegal, and the officer claims to smell weed. Solution: refuse consent, comply physically, and avoid self-incrimination. Don't say you just came from a legal state or only have a small amount. That's a confession. Why it works: courts cannot use evidence from an illegal search if you didn't consent and didn't incriminate yourself. Your silence preserves the argument for suppression later. Let's discuss the physical search itself. When an officer requests a pat-down, it's legally limited to weapons. The Supreme Court's Terry v. Ohio decision allows a frisk for officer safety, not for drugs. They can only seize an item if its criminal nature is immediately apparent. THC oil cartridges, gummy packets, or small buds in a pocket don't meet that standard. But if you react nervously or reach for the item, you create the plain feel justification. Again, control your movements. Problem: the officer pats you down and feels something in your pocket. Solution: do not reach for it or explain. Stay still and repeat, "I do not consent to any searches." Why it works: any physical resistance converts a questionable search into a lawful arrest for obstruction. Calm verbal refusal keeps the encounter legally clear. Now let's move inside the vehicle. Many people think locking their glove compartment or trunk prevents a search. It doesn't. Under the automobile exception, once probable cause exists, officers can search every compartment that could contain the object sought. If they say they're just checking for safety, it's usually a search in disguise. Always ask, "Am I being detained or am I free to go?" That single sentence does three things. It defines the encounter type, clarifies your legal status, and puts the officer on record. If you're free to go, leave immediately. If detained, say, "I'd like to remain silent." And finally, a word about the smell argument. In 2025, courts increasingly recognize that hemp, CBD, and legal cannabis products smell identical. The human nose can't distinguish between them. Laboratory analysis is required to confirm THC concentration beyond 0.3%. That means your car could smell like cannabis without any illegal content whatsoever. Problem: the officer insists that odor is evidence. Solution: never argue science. Just say, "Officer, I understand, but I do not consent to any searches." Why it works: you're not challenging authority, you're asserting law. That calm refusal becomes a clean record your lawyer can use later. Before we move to part 2, let's solidify your mindset. Police encounters are not debates, they're data collection. Everything you say, every movement you make builds the officer's probable cause narrative. Your job is to deprive that narrative of material. So remember these first core principles. 1. Smell isn't guilt. 2. Calm is strategy. 3. Silence is protection. 4. Consent is optional. In the next segment, I'll walk you through the exact police tactics officers use to justify searches, how they extend stops, manipulate language, and use pseudoscientific tests to make evidence appear out of thin air, and how to counter each one without escalating. The police tactics officers use to justify searches. You're sitting in your car on the roadside. You've already said, "Officer, I do not consent to any searches." You've done everything right. Yet, the officer doesn't step back. Instead, they start talking, slowly, softly. "You know, if you've got nothing to hide, why not let me take a quick look?" That sentence isn't casual, it's tactical. Police academies train officers to use conversational leverage, not brute force. Every pause, every friendly tone is designed to make you feel that refusal equals guilt. Here's how it really works. Officers are taught what psychologists call compliance escalation loops. Small, seemingly harmless questions that gradually increase social pressure. Where are you headed? How much have you smoked today? Can I take a quick peek? They know your stress hormones, adrenaline and cortisol, are already elevated, clouding reasoning. Your brain shifts from logic to survival. That's when people give consent they didn't mean to give. Let's decode the most common tactics, one by one. Tactic 1. The friendly cop approach. They'll lower their tone, smile, and act understanding. "Hey, I don't care about a little weed. I just need to make sure everything's cool." The goal is to reduce your guard and get voluntary consent. Problem: you mistake friendliness for leniency and give up your rights. Solution: match tone but not compliance. Calmly repeat, "I understand, officer, but I do not consent to any searches." Why it works: you acknowledge respect without surrendering legal ground. Politeness disarms manipulation while your refusal preserves your constitutional leverage. Tactic 2. The fear trigger. They may say, "If you don't let me look, I'll just call a K9 unit." That's designed to make you panic and submit. But here's the truth. Calling a K-9 unit requires reasonable suspicion, and courts have ruled that detaining someone longer than necessary for a traffic violation just to await a dog can violate the Fourth Amendment. Problem: the officer threatens an extended stop. Solution: don't argue or panic. Ask, "Am I being detained for a specific reason?" and document the time. Why it works: this locks them into accountability. If they detain you without reasonable suspicion, any evidence later found may be suppressed in court. Tactic 3, the pretextual stop. You're pulled over for something trivial, a broken taillight, drifting within your lane, and the officer uses that as an opening to fish for drugs. It's legal, but the Supreme Court's decision in Wren v. United States allows it as long as there's a legitimate traffic reason. However, officers often overstep by expanding the scope. Problem: you're stopped for a minor traffic issue but questioned about drugs. Solution: redirect to the reason for the stop. Say, "Officer, am I receiving a citation or am I free to leave?" Why it works: it forces a procedural reset. If they continue questioning beyond the traffic matter without reasonable suspicion, their actions may become unconstitutional. Tactic 4, the smell narrative. Even in 2025, this remains the most powerful pretext for a search. But here's what they don't tell you: scientifically, odor detection is subjective. The olfactory threshold for terpenes varies up to 300% among individuals. Fatigue, humidity, and even diet alter perception. One officer might detect nothing, another might swear your car reeks. Courts increasingly question this subjectivity, especially since hemp and cannabis share identical aromatic compounds. Problem: officer claims to smell marijuana. Solution: stay silent and reaffirm your refusal to consent. Don't react defensively or ask, "You can smell that? That sounds confrontational." Why it works: remaining neutral deprives the officer of behavioral cues that support their narrative of suspicious conduct. Tactic 5, the plain view gambit. They'll angle their flashlight inside your car hoping to spot rolling papers, ash, or vape residue. Once something's in plain view, they can seize it without a warrant. Problem: you left paraphernalia visible. Solution: always store personal items in closed containers, out of sight. Why it works: the plain view doctrine applies only when the object's incriminating nature is immediately obvious. A sealed container creates ambiguity. Officers then need probable cause to open it. Now let's talk about the physiological traps, the signs your body might betray you. When THC enters your bloodstream, it binds to CB1 receptors in your brain, particularly in the basal ganglia, hippocampus, and cerebellum. These receptors regulate coordination, short-term memory, and perception. That's why users may exhibit delayed responses or subtle eye tremors. Officers look for those cues, but here's the science. These effects depend on dosage, frequency, and tolerance. Regular users may have zero impairment even with detectable THC. So if you've consumed legally hours earlier, your pupils might still appear dilated and your eyes reddened. Those physical signs alone are not evidence of intoxication. Problem: the officer claims you look high. Solution: don't respond with explanations like, "It's allergies" or "I smoked last night." Simply say, "I don't wish to answer any questions." Why it works: you deny them verbal corroboration. Without a confession, red eyes remain a vague symptom, insufficient for probable cause. Now, let's address the next layer of manipulation: field sobriety tests. These roadside tests, the one-leg stand, the walk and turn, the gaze test, were designed for alcohol impairment, but cannabis affects coordination differently. Studies by the National Institute of Justice show up to 50% of sober participants fail these tests under THC-only scenarios. Even fatigue or anxiety can trigger failure, yet officers still rely on them. Problem: you're asked to perform a field sobriety test. Solution: in most states, you have the right to decline. If you do, say calmly, "I respectfully decline all voluntary tests." Why it works: you avoid unreliable assessments that can falsely establish probable cause. Be aware, refusing may lead to temporary detention or license suspension depending on state law, but it strengthens your legal defense. Then there's the drug recognition expert, or DRE, a police officer with special training to detect impairment without chemical proof. The DRE protocol involves 12 steps, from pulse checks to muscle tone exams, but it's deeply flawed. THC doesn't raise heart rate predictably, nor does it constrict pupils consistently. In 2025, several courts have labeled DRE testimony as pseudoscientific. Problem: a DRE claims you're impaired. Solution: remain silent. Never argue the science. Why it works: arguing lets them interpret agitation as confirmation. Your calm silence preserves the record for your attorney to later dismantle the DRE's conclusions in court. Now let's go deeper into consent psychology, the subtle tricks that turn voluntary into involuntary. When you say, "Sure, go ahead and look," you've given them a blank check. They can open every compartment, every bag, but you can withdraw consent anytime. That's rarely taught. If you realize mid-search that you made a mistake, say, "Officer, I withdraw my consent." From that moment forward, anything found found can be challenged as illegal if they continue. Another trick, the group pressure effect. If multiple officers arrive, one may engage you conversationally while another circles the car. This is intentional. Dividing your attention makes it easier for them to manipulate consent through distraction. Problem: multiple officers surround you, one friendly, one silent. Solution: focus on the one who initiated contact. Repeat, I do not consent to any searches. Do not turn your back or multitask. Why it works. You maintain a single point of communication and avoid being manipulated by parallel questioning. Also be aware of the recording trap. Officers wear body cameras. They rely on your voice and movements to justify their narrative in reports. Every word you say is evidence, the best footage. For your defense is calm, polite, and minimal. Problem: you feel pressure to explain yourself on camera. Solution: say only, I do not consent to any searches and I wish to remain silent. Why it works. Those statements are constitutionally powerful. They show composure, awareness, and zero aggression. Now, a key physical truth most people overlook. THC doesn't metabolize like alcohol. It's fat-soluble, stored in body fat, and released slowly over days. That means even if your blood shows THC, it says nothing about current impairment. Officers may push for blood or saliva samples, but without a warrant, you can refuse. In most states, chemical testing requires probable cause plus consent or a judicial order. Problem: officer demands a drug test without a warrant. Solution: say, I do not consent to any test without a warrant. Why it works. You're invoking both your 4th and 5th Amendment rights. No unlawful search of your body and no self-incrimination. Finally, remember, your calm resistance isn't about defiance, it's about discipline. Police control chaos through confidence. You reclaim control through composure. Everything I'm telling you boils down to a single formula. Silence plus stillness plus last clarity, on my point, legal power. When adrenaline floods your system, the instinct is to talk, explain, justify. But every extra word is evidence you volunteered. In court, officers will say, the suspect admitted to smoking earlier, or he appeared nervous and evasive. Let the only thing they can quote be, I do not consent to any searches. In the next segment, we'll close this loop. I'll walk you through what happens after a search, how evidence suppression works, how to recover from an arrest, and what the real-life consequences look like when you win versus when you panic. This is where knowledge becomes protection. The legal consequences and how to turn control back in your favor. When the flashing lights fade, when the adrenaline drains, that's when most people make the biggest mistakes. Not during the stop, after it. They start venting, calling friends, posting on social media. They say things like, the cop had no right to search my car. But if you've said even one incriminating sentence during that stop, that's what prosecutors will play in court. Not the officer's overreach, but your own words. Let's be clear. In the real world, most searches for weed don't end in violence or headlines. They end quietly, in handcuffs, paperwork, and a record that shadows your future. That's why your goal isn't to win on the roadside. Your goal is to win later, in court, with evidence on your side. So let's break this final section into loops. What to do during the search, what happens if you're arrested, and what the legal consequences really look like depending on your state. Problem: the officer begins a search despite your refusal. Solution: stay still, keep your hands visible, and do not interfere. Repeat once. Officer, I do not consent to any searches. Then go silent. Why it works. Physical compliance prevents escalation. Verbal clarity preserves your right to challenge the search later. Courts distinguish between cooperation and consent. You can comply without agreeing. Next, document. If you can safely record, do it. If not, remember details. Badge numbers, patrol car markings, exact words said. As soon as possible after the encounter, write everything down. Memory fades fast under stress. Within hours, small details vanish. Those details could be what your attorney uses to suppress evidence later. Let's talk about Miranda rights because most people misunderstand them. Police don't have to read you your rights until you're in custody and they begin interrogation. If you're simply detained or questioned roadside, silence is still your protection, even if they haven't read Miranda yet. When you hear, you have the right to remain silent, that's not permission to start talking. That's your warning to stop. Say, I want a lawyer, nothing else. Once you invoke counsel, questioning must cease. Any statement afterward can be excluded in court. This single sentence has saved more cases than any courtroom speech ever could. Now let's discuss the aftermath. What happens legally when a search leads to discovery? Even in 2025, marijuana remains federally illegal under Schedule I of the Controlled Substances Act. That classification means no accepted medical use and high potential for abuse, even though 24 states now allow full recreational use and 40 allow medical programs. This conflict creates confusion, but it also creates leverage for defense. Here's how it plays out. If you're in a legal state, say California, Illinois, or New York, possessing a small lawful amount shouldn't trigger arrest, but exceeding your state's limit, using publicly or carrying open containers can still justify citations or misdemeanor charges. For example, in California, possession over 1 ounce can carry up to 6 months in jail. In New York, over 3 ounces may lead to misdemeanor prosecution. If you're in an illegal or restricted state, Kansas, Idaho, Wyoming, any possession can lead to arrest. In some, even CBD oil remains restricted. The smell of cannabis there can still count as probable cause for a search. Penalties vary, up to 1 year in jail and fines of $1,000 or more for simple possession. Years of prison for cultivation or intent to distribute. Now, here's what most people never learn. Even if charges are dropped, the arrest record stays until it's expunged. Employers, landlords, schools, even immigration officials can still see it. Expungement, clearing your record, isn't automatic everywhere, though more states now offer it for minor weed offenses. That's why lawyers focus not just on winning cases, but on erasing evidence of them. If your attorney files a suppression motion and the court agrees the search was unconstitutional, any evidence found, the weed, paraphernalia, test results, becomes inadmissible. Without evidence, prosecutors often dismiss charges. Problem: you're charged after a search. Solution: hire a criminal defense attorney immediately and tell them everything, especially the exact words you used during the stop. Why it works: precise phrasing determines whether your refusal counts as valid. The attorney can file a motion to suppress, arguing that the search violated the Fourth Amendment. If that motion succeeds, the court excludes the evidence. It's as if the search never happened. That's your legal victory. But it only works if you stayed calm and didn't consent. Now let's discuss the quiet consequences, the ones that last long after court. A drug conviction, even a misdemeanor, can block job offers, suspend professional licenses, revoke firearm rights, or deny housing. For non-citizens, it can trigger deportation. Even college students risk losing federal financial aid. These are called collateral consequences, penalties that follow you beyond the courtroom. But there's a way out. Most legal states now allow record sealing or automatic expungement for non-violent weed-related offenses. Check your state's judicial website or contact a criminal records attorney. The process is often free or low cost and can completely restore your record. Now let's connect this back to biology and reason. The smell of cannabis, the trigger for so many searches, isn't proof of intoxication. It's a chemical signature. The terpenes that create that odor linger in clothing fibers, vehicle upholstery, even hair. That means the scent in your car could come from someone who smoked near you hours earlier. There's no biochemical test that distinguishes presence from use. And yet, officers continue to use smell as shorthand for suspicion. That's why knowledge of your rights isn't optional, it's armor. Problem: you're released after a search with a citation or warning. Solution: don't celebrate yet. Take photos of any damage to your vehicle, write down the event, and contact a lawyer for a quick review. Why it works: even a harmless search may have violated protocol. A lawyer can request body cam footage or dash cam logs, often revealing rights violations that justify legal remedies or complaints. In other words, your calm today builds your defense tomorrow. Now, a few closing realities. The relationship between cannabis and law enforcement is evolving faster than the laws themselves. In 2025, multiple appellate courts, including those in Florida, Illinois, and Minnesota, ruled that smell alone is insufficient probable cause for a search. But in states that haven't legalized, smell remains the single most abused justification for detention. Federal law hasn't caught up. On federal land, national parks, military bases, federal housing, any possession is still a crime. So even if you bought legally in one state, crossing into federal jurisdiction reactivates those penalties. That's why I tell my clients this: your rights travel with you, but the law doesn't. Let's end this where we started. You're pulled over. The officer leans in and says, "I smell weed." What happens next depends entirely on your response. Not your background, not your state, not your luck. Your response. You don't need to be rude. You don't need to argue. You just need to stay anchored. Say calmly, "Officer, I do not consent to any searches. I choose to remain silent. Am I free to go?" Then stop talking. Because the moment you stop talking, you stop incriminating yourself. You stop feeding the report. You stop helping the prosecution. Remember, silence is not weakness, it's strength. Calm isn't submission, it's control. When you act with composure, you're not defying authority. You're exercising it. Your authority over your own rights, your body, and your future. That's how you protect yourself in 2025 and beyond. So here's my mission for you. Educate one person about this. Send them this knowledge. Because every informed citizen lowers the chance of an unlawful search, one traffic stop at a time. You can't stop an officer from lying about smell. You can't stop bias or overreach, but you can stop handing them power they didn't earn. Your calm is your shield. Your silence is your sword. And your knowledge, that's the law, working for you. Like this video? Click on the card showing on your screen for more.